Can everybody hear me? I assume yes? Okay. My name is Laura Revolinski, and I'm one of the symposium editors here at the Duke Journal of Comparative and International Law, and thank you all so much for coming to our symposium. We are all so excited to have you here. We have a great lineup of speakers, and I'm sure this is going to be an amazing event, one for the ages. I just wanted to make a few thank yous before we get started. First off, I wanted to thank Professor Michaels, who's really been the brains behind this operations. This really is his brain baby, and we're just the elves that made it happen. And also, our editor-in-chief, Garrett Brodeur, he couldn't be here, but our managing editor, Emily Weiss, is here. And thank you, Garrett and Emily, for cheering us on all the way and being very supportive. Also, John Epling is my fellow symposium editor, and he is the reason that you all have beds to sleep in and food to eat, and the reason that we are in a classroom right now. He was responsible for all of those logistics. So thank you, John, for all of that work. And also, Rick Stubbs, who is the reason that everybody made it here today. He was the coordinator of all the rides, so he did a great job with that. He's probably, oh, there he is in the back. Thank you, Rick. And also, I'm very excited to introduce a very special guest. He's the dean of our law school, so it's a pretty exciting deal that he is here. And also, he was recently elected to be president of the American Law Institute to begin serving in May of 2017. So we are very excited to introduce Dean David F. Levy.
Thank you, and welcome to Duke. So these are the, I'm wearing principally my dean hat at the moment because I'm welcoming you to Duke, as I often do at conferences. But also, as was just said, I'm succeeding Roberta Ramo in a year, and so I'm here also on behalf of the American Law Institute. So bless you for coming here today to talk about the Third Restatement, which will be coming to the Council, I think, for the first time in January, or coming back, I should say. So it's fit and proper that you are here at Duke because we were one of the principal homes for Brainerd Curry. He was here for many years. So we shared him with Chicago over the length of his career. He went back and forth some. We just had the Curry lecture here last month, and of course Ralph Michaels is one of the leaders in conflict of laws, and Steve Sachs is an advisor on this project. And at some point, I think you'll have to take account of the work of the Restatement of Foreign Relations, probably, and Kurt Bradley is one of the reporters on that ALI project. And I'll just mention that Deborah DeMott, I don't know that you'll get into agency law, probably not so much, but she was the reporter for the Restatement of Agency, and did such a marvelous job there. Just something about the restatement of conflicts. It seems that it always engages the leading lawyer, academic minds of that generation. When I don't know what it is, Ralph and I were just talking about that. Is it because it deals with such fundamental questions about the nature and sources and purposes of law? It's difficult. I remember that from my student days. It's occasionally esoteric, and it requires a good deal of mastery in order to work to gain mastery. The first reporter was Joseph Henry Beale, going back to my youth. He was the first dean of the law school at the University of Chicago. Can you believe it? The first dean. And then produced this first restatement, which immediately was dismissed by the Academy because it relied on principles of territoriality, and so it was released and sort of poo-pooed at the same time. And then Willis Reese, who was the Hughes professor, Charles Evans Hughes professor at Columbia, came along, and it took 20 years for that group, for the ALI of that time to finish the work. And I was just flipping through it to see whether Curry had been an advisor to that restatement, and he was not. But Henry Friendly and Erwin Griswold and a few others, Paul Freund, et cetera, were. Professor Reese also developed the LSAT in 1948, so he should be popular with all the law students in the room. And that brings us to now, the restatement of Third, and what a wonderful, strong set of reporters and advisors that we have. I think, speaking for the ALI, this is a dream team in the conflicts world. It's really wonderful judges, lawyers, and academics, some of the real leaders in this field, and the three reporters are all terrific and have great reputations. So we've moved from territoriality to a rules-based approach with some presumptions, the significant relationship test. It's somewhat complex. When I was a judge for 17 years, I liked these cases. My law clerks did not, however, and weren't much use to me. So maybe the third restatement will be helpful to law clerks. That's sort of a joke, actually. But if it were simpler and perhaps somewhat more specific, that would be helpful. And then, of course, the reason why we are here today, which is that a new restatement should take account of the international community and what is happening in the sphere of international law. The EU has choice of law codes now for torts and contracts, and there are a lot of developments in the world of conflicts around the world that we should take account of. And at the time of the second restatement, even though it spanned those 20 years from roughly 1950 to 51 to 71, that was well in advance of many of the ways in which we do business now through email and the internet, et cetera. And the ALI has not stood still during this time. So we have had projects on class actions, on judgments, and foreign affairs, and all of that, I think, is something you'll want to take account of in the third restatement. So it's a very tall order, and but as the Cubs have demonstrated, you are up to it. But you have a worthy opponent because it's a very difficult field. So welcome to Duke, and Ralf, it's always a pleasure to do anything with Ralf Michaels, and so I'm sure you'll experience that pleasure as well. Thank you.
Thank you, David. Thank you, Laura. Thank you, Journal team, for setting up a conference that's bigger than the conferences that the Journal usually sets up. And partly that is because you wanted that, partly because I pushed for it, although biologically I'm not sure what a brainchild would be. Partly it's because I saw what John Coyle does at UNC, and I figure we really have to compete with UNC on this as well. But thanks, I'll start with that. Thanks to the students for all the hard work that you've done in this and the hard work that you'll still do over the next 2 days, and possibly in editing an issue after this. I'm really excited and thankful for that. I think it's an important theme, and it's an important conference, and it's an important issue when it comes out. We talk about the Third Restatement of Conflict of Laws, and we talk about internationalizing the restatement. That means especially saying, first, we look at how conflict of laws plays out in the international realm as opposed to in the interstate realm, which is where much of the discussion and the focus has been for some time, almost exclusively in the Restatement Second, and still in much of the scholarship. And in relation with that, we look at the role that comparative law can play in a third restatement for conflict of laws. In some ways, both of those aspects could be asked for any restatement. Deborah DiMato, who was mentioned before in her agency restatement, uses a lot of comparative law, especially looking at English law, to draw on comparison. And we can say it's not intrinsic to a restatement that it has to be purely domestic. Restatements have at least two functions. One is descriptive and one is prescriptive. The descriptive function is to describe, order, rationalize the law as it is found. The prescriptive function is to lay out rules, principles, approaches that judges and practitioners can actually use. As to the prescriptive approach, you can see why both international conflicts would have to be taken into account, and also why comparative law could be helpful and useful. Because, as we know, we find insights in foreign legal systems that we may not find in our domestic systems. sometimes substantive solutions, but sometimes just doctrinal solutions, ways in which problems are addressed in other legal systems that are helpful and instructive for the formulation of our own rules in the United States. If the cliche is true that common law systems are especially good at precedent, and it may be true that the flip cliche is true that it's civilian systems that are especially experienced in drafting rules, and then especially civilian systems could teach the drafting process of a restatement. But it's even true on some level for the descriptive function. We could say a restatement just restates the law as it exists in the United States. But conflict of laws has a strong international tradition. Conflict of laws is more or less invented as a field that deals with relations between different legal systems, and is translated in the Netherlands into one that actually deals with relations between different sovereign states. Once sovereignty is invented, it is translated into questions of conflict of laws. That's the Netherlands, that's far away, but when Joseph Story really writes the first modern treatise of conflict of laws, he not only borrows from Dutch conflict of laws in terms of doctrine and principles, he also, in principle, borrows the sovereigntist approach. It's an odd thing because it talks really about relations largely between the laws of different states of the United States. But his take is that we can treat the relations for conflict of laws purposes for in many ways as those like between sovereign states elsewhere. That's especially the reason why he says no, whether foreign law is applicable in the state is entirely a sovereign decision of the state that makes the decision. In that sense, we've always had this curious field of conflict of laws that even where it focused on relations between the states of the United States, had a strong sovereigntist background. It meant on the one hand, there was an internationalist strand to it. And on the other hand, it meant that there was not a lot of awareness that international conflicts could actually be different, could have developed in ways that are different from what we have in the United States. In that sense, even the descriptive function would benefit from looking at what happened to these internationalist approaches elsewhere in other legal systems. But then there's a further reason why it's really important to look at comparative and international law for such a restatement, and that is the fact that what is being restated here may be a restatement of US law, but becomes really a globally relevant and important corpus. We see that most prominently in public international law. The restatement on foreign relations law is really treated as a restatement of international law in large parts of the world. That was true at least for the last edition. I don't expect the same will happen for this one because this one's much more focused on foreign relations as opposed to truly international law principles. But restatements have this role. The first restatement of conflict of law is widely discussed in other countries. I know discussions in France, there are discussions in Germany. The second restatement is taken as the expression of conflict of laws as it exists in the United States, even though we find a lot of criticism of it in the United States itself. So the third restatement, when it comes out, will become a prominent, important codification, restatement of private international law, not just for the United States, but also for the rest of the world. And I think that is a good reason to take into account the rest of the world at this stage, at the stage of drafting as well. I should close there, but I should close by thanking more people. I want to thank Mark Dietrich, whom I saw somewhere, who's writing a conference report in German, I hope, for this. I will hope someone else writes a conference report in English. I just pronounced that this morning, so I think no one has been assigned that task yet, but I hope someone can be found so we can tell the ALI what we've been doing here. I want to thank Peter and Paul, Peter Winship and Paul Dubinsky, who came to the conference, so we have a broader circle really here of expert discussants. I want to thank all the speakers who came and said, we're part of this, we're helping in this project of internationalizing conflict of laws. When I came to Duke, I was excited to be hired by a fabulous law school and the law school of Cavers and Curry. But I also thought this is far off. It may be hard to get people here. Everyone on my top list came to this conference, including people who had before been harder to get here. So I'm very, very pleased by that. And I thank all of you for the contributions that you're going to make. And last, I want to thank the 3 reporters of the restatement for going into this. The reporters have said that they find this very helpful, and that may be the case, and I hope it is the case. But it's a real openness to say we do this, we take in this kind of inspiration, this kind of help and advice. They already get bombarded by what the advisors say to them once a year. So it's really not just thanking them for putting together what is going to be a fabulous restatement, but also really coming to this to learn, to listen, to participate in the debate that we'll have. I hope we have 2 exciting half days in front of us, and welcome you, and thank you all for coming. I now lead over to Chris Whytock, who is actually a Duke graduate, or a PhD graduate, and is one of the 3 reporters of the restatement, and a professor at the University of California in Irvine.
Thank you, Ralf. And Ralf was on my dissertation committee. I think that's probably true. I'd like to thank you all for coming, and on behalf of Kim and Laura, thank you all for coming. And I'd like to thank Ralf, who had the idea for this gathering. I'd like to thank Ralf and Laura and everybody else in the journal for coordinating, Dean Levi and the Duke Law School for making this possible financially, and also just to reiterate, the American Law Institute also contributed financially to make the conference possible, to bring all of you in. So many thanks to the American Law Institute, and thanks to Matthias Reimann for coming out. His work helped inspire this conference. And I wanted to start with one of the rationales for the Third Restatement that Kim Roosevelt, the principal reporter, sent in his proposal for a Third Restatement of Conflict of Laws. And the letter says, perhaps most significantly, a Third Restatement would provide an opportunity to pay greater attention to the international context than the Second Restatement did. Conflicts issues, whether choice of law, recognition of judgments, or domestic relations, now frequently involve not 2 U.S. states, but a state and a foreign country. It would be valuable to assess the Second Restatement rules in light of the increased presence of international factors, and also to consider attempts to learn from or harmonize with foreign approaches. So this is very much at the core of the Third Restatement project. And one of the primary motivating purposes of the symposium is to spend some time working with all of you to try to reach this particular objective of the Third Restatement project. And so we're very eager for all of your suggestions and your insights. The project is in the early stages. We did circulate earlier the most recent draft submitted to the project advisors in this fall. So there's certainly some material that you might have looked at and you could address critically during our meetings today. But I mostly want to emphasize that we're still at the early stages. So all of your input and suggestions can be extremely valuable. Here's where we are roughly. In fall of 2015, we presented to the advisors for the first time. We presented 3 sections: an introduction to the restatement. We presented a section on habitual residence and domicile. And we presented a chapter on the determination of foreign law. And we got feedback on those chapters. We revised those and presented them this fall. We also presented drafts of a portion of the section on torts and on property choice of law issues. And next week, actually on Monday, we have a deadline for submitting the introduction, the domicile habitual residence section, and the foreign law section to the ALI Council. We expect our additional work to include sections on contract, choice of law issues, domestic relations, sections on personal jurisdiction, perhaps some other choice of law topics, including there's been some discussion about trying to incorporate intellectual property choice of law issues, trusts and estates, so other core areas of conflict of laws, and the recognition and enforcement of foreign judgment. So there's a lot ahead of us, and I anticipate at least a few more years of opportunity for all of you to provide feedback. So in short, most of our work lies ahead of us. So again, this means that your suggestions can play an important supporting role as we try to take into account both the international conflict of laws issues and the comparative perspectives. The specific items on the agenda for today and tomorrow include tort, contract, and family law, choice of law issues, as well as jurisdiction. But I think just as important, there are a couple pervasive themes that Ralf already touched on. And the first is how can we and how should we incorporate comparative materials into the restatement? Each of us have already done that to a significant degree and to sometimes to a greater extent apparent in the reporter's notes, sometimes less apparent, but it's already been playing a role. Certainly could be some discussion about how visible that should be in the actual work product and additional ways that we can take comparative perspectives into account. And then second, to what extent should conflict of laws rules for international conflict of laws issues be different from conflict of laws issues at the domestic level? And this has, of course, been quite a long debate in the field, but now is an opportunity to try to take some lessons from this debate and put them into practice in the restatement. The current approach of the draft is reflected in section 1.04 of the Third Restatement. And our general intuition is that, for the most part, the rules that work for domestic conflicts should work for international conflicts, but there are some obvious places where they don't, and then I think there are a lot of less obvious places where they might not work. And this is, I think, as we're going through the topic-specific issues today and tomorrow, that's one area where we'd be especially appreciative to have feedback. We all look very much forward to our conversations, are eager to hear your suggestions, and thank you again for participating, and thanks again.
So we need 2 more people. Two chairs, each of them, which is a lot of chairs. It's unusual, it was Chris's idea, so I'm speculating a little why we have that. I will view my task to be really almost exclusively that of timekeeper and calling on people. And I expect Chris, in this role of reporter, will see if he wants to guide the discussion in ways that are most helpful to the project. Is that in accordance with what you would have in mind? So with that in mind, we'll start with Symeonides, who talks about what we can learn from codifications around the world. And I will ask everyone to speak no more than 20 minutes, and in order to really enforce that, I will put an iPhone with a down-running clock in front of each of them. And it self-explodes after 20 minutes.
I can start talking anyway.
Make sure that the screen doesn't shut off. I'm never sure about that.
If you put something up there, but
Right, yeah, the sidewall is coming on the projector itself. It's not coming on.
direct their attention to them.
So we have that on the screen back there.
No, well, by the time we figure out the technology, it'll be 10 minutes long. It was never on. Oh, there it is, okay. Okay. Well, I didn't touch anything, okay? That's not my fault. Well, I want to begin by thanking the editorial board and Ralf for inviting me and for including me in this august group of conflicts experts. It's a real treat to be with you, and I look forward to our discussions in the next few hours and tomorrow. Okay. Okay. I will try to speak as fast as I can without eating more than 1/3 of my words. Okay, you see my topic, choice of law codifications in the last 50 years and what can we learn from them in this process. I draw from a book that I published in 2014, which covers the codifications of the year between 1962 and 2012. For the purposes of this presentation, I added a few more, so we are covering 54 years total. So as you can see, there has been a lot of activity in these 50 years. These are all the codifications chronologically for this period. These are all the EU regulations that involve choice of law matters, Hague Conventions, and Inter-American Conventions. Altogether, 164 instruments. Same thing by decade. If you add some protocols and uniform laws, you get the total of 196. And this is really the most productive period since the birth of Bartolus. Not just the most productive 50-year period, but altogether, more than the previous 650 years altogether. And you may wonder what are the reasons for this intense codification activity. Of course, some obvious reasons: the decolonization of Africa and parts of Asia, the collapse of the Soviet Union and the formation of new independent states, the EU and the eagerness of various new countries to join the EU. A lot of them codified their laws as a condition almost of approximating their laws to the EU. But there are additional reasons, like the upsurge of cross-border activity, and perhaps the realization that clear and predictable rules are necessary for cross-border intercourse and cross-border commerce. If we cannot harmonize our substantive laws, if we cannot even agree on choice of law conventions, which we draft but usually don't ratify, let us at least state our own choice of law rules in a clear and predict in a clear manner, so that parties can know what they are going into when they engage in cross-border activity. Geographically, this is how the new codifications are spread out. You see most of them in Europe, some of them, the old ones, in Africa, and some in Latin America. Europe is the lion's share, of course, and we're not talking about the EU regulations. We're talking about national codifications. And here you see the various countries, some of which were members of the Soviet bloc, now members of the EU or not. The Asian codifications, there you see in red some of the former Soviet republics. The African codifications, they are mostly from the 1960s, and they tend to be short and tend to copy either the Portuguese or the French model. And then in the Americas, remember, we are only talking about this 50-year period. Other Latin American countries have codifications which are, of course, older. And the new codifications, the old model was that they tended to be part of a civil code, usually the preliminary title or the first book. The new codifications, some of them continue that tradition, but others are freestanding statutes, and they tend to be longer because they include not only choice of law, but jurisdiction and recognition of judgments. And some of them are quite short. The longest is the Swiss codification, which is 200 articles, followed by the Serbian draft and the Romanian codification, and so on. Okay, this is a general description of what has been happening. Now, some of the general features of these codifications. It is not your grandfather's codification. Today's codifications are much different than those of the previous generation. They are more comprehensive, complex, flexible, clever, pragmatic, pluralistic, and eclectic, and less idealistic, pure and innocent. Modern codifications provide certainty through black letter rules, but they also inject controlled dosages of flexibility through soft connecting factors and escape clauses intended to ensure adaptation to changing needs and individualized handling of exceptional cases. They continue to engage in state selection, what David Cavers called jurisdiction selection, rather than direct content-dependent law selection, but they are far from indifferent to what is being chosen. The classical conception of the choice of law process, statutory or judicial, as a blindfolded, value-neutral exercise does not reflect today's realities. They continue to aim for Savigny's and Kegel's conflicts justice, but they have also made serious targeted concessions to the desideratum of material justice. 82 of the 86 codifications enacted in geographically dispersed and culturally diverse countries in the last 50 years have adopted result-selective choice of law rules, which favor the validity of testaments, contracts, or other juridical acts, favor a certain status, such as marriage or legitimacy, or certain parties, such as tort victims, consumers, employees, maintenance obligees, and other presumptively weak parties. And although these rules are analytically exceptional, their numbers are too high and their use too widespread globally to be dismissed as inconsequential. They are not. Their ubiquity demonstrates that concerns for material justice are not uniquely American. They consist primarily of bilateral choice of law rules, but they also selectively employ unilateral rules and other unilateralist tools whenever important forum interests are at stake. There is hardly any private international law codification that does not contain some unilateral choice of law rules. There is almost no country in which mandatory rules do not enjoy priority over choice of law rules, bilateral or unilateral. And there is no country that does not have localizing rules interspersed in substantive statutes mandating the application of those statutes to an increasing range of cases that have certain conducts with the forum state. These rules protect not only economic interests of the forum state, but also certain strongly held societal values and beliefs in traditional private law fields, including contracts, marriage, divorce, maintenance, property, and successions. For example, ensuring equality in marriage or facilitating divorce, as some of these rules do, does not protect an economic interest, but promotes that society's sense of equality and freedom to marry. These codifications continue to view conflict law as private law, but they also concede that it often implicates important public interests, which must take precedence over other values. They continue to subscribe to the principle of equality of forum and foreign law, but they also subtly protect the interests of the forum state in selected areas. In tort and contract conflicts, modern codifications have made significant substantive and methodological advances and have reached results similar to those reached in the United States after the Revolution, thus suggesting that progress can be achieved without a revolution. In tort conflicts, the most significant developments are the widespread acceptance of the favor lesi principle in cross-border torts, the common party affiliation exception to the lex loci rule, and the closer connection exception to the lex loci rule. In contract conflicts, party autonomy has become a universally accepted principle, but important differences remain with regard to its parameters and modalities. Which contracts does it apply to, which issues in contracts, and so on, and which states' limitations are used to police party autonomy. There is a great degree of emulation, borrowing, and transplantation, especially from the sophisticated Western European codifications to Eastern European and Asian codifications. For example, the influence of the Rome Convention is pervasive. However, more often than not, the borrowing is not mechanical and subservient. It is usually accompanied by shrewd adjustments carefully crafted to accommodate the national needs, interests, and values of the borrowing country. To what extent have these codifications been influenced by American developments, especially the European codifications? Several European authors seem to acknowledge this influence. I will not quote them all. Other authors see less of an influence, but they acknowledge that the American developments have prompted European lawmakers, judges, and academics to reconsider their methods and solutions. On balance, Peter Hayes' observation about a conscious parallelism is the most accurate description, I believe, because after all, even when acting in isolation, comparable legal systems tend to react similarly to the same challenges. This parallelism is more obvious in substantive solutions. For example, there is a surprising similarity between the way American courts resolve tort conflicts and the solutions adopted by most of these codifications in Europe and elsewhere. The parallelism in methodology and form is less obvious, but it does exist. For cultural reasons, Europeans opted for evolution rather than revolution, but they have moved in the same general direction as American private international law. For example, we went from the one extreme of total rigidity of the First Restatement to the other extreme of total flexibility. European private international law moved cautiously and slowly away from rigidity by softening the old connecting factors and introducing escape clauses. But both systems have moved from rigidity to flexibility, albeit in different speeds and degrees. So if you want to summarize some of our differences with the Europeans and other civilians, Americans act judicially, Europeans act legislatively, we act directly and overtly, they act indirectly and covertly, we stake out positions, extreme positions and then tend to moderate them in application. Europeans profess idealistic positions, but in practice they are far more pragmatic. So now, what can we learn from these codifications? Obviously, a restatement is different from a code or a statute, for better or worse. In a statute, you cannot use words such as usually, which is used about 1,000 times in the Second Restatement, in the black letter, I mean, or perhaps, which is used in the Third Restatement of Foreign Relations. A restatement is written from the perspective of a neutral forum, as Willis Rees told us some time ago, and that is good and bad. For example, it means that you cannot use unilateral rules, which are the most precise instrument for protecting legitimate forum interests. Okay. I would not put this in writing, and with all due respect to my European friends, but I believe that, and I can say that because I'm half European, I believe that American choice of law thinking is ahead of European thinking, but we can still learn from them, both from their advances and their mistakes, in the same way they have learned from our excesses. Some general points. At the very least, we can learn from their rich experience in rule crafting. For example, they have succeeded in striking what they consider the appropriate equilibrium between certainty and flexibility. Our own balance will be different. We need and we can afford more flexibility, although less than the second restatement. Our approach should combine an approach and with rules. We should have one general section that articulates the general approach of the whole restatement, the general philosophy, followed by specific rules extracted from the general approach for only those cases or issues for which the case law yields uniform decisional patterns, followed by escape clauses which are anchored on the general approach, but not as many escapes as the second restatement, and then leave the remaining issues and cases to the general approach. So if you want to see where I hope our new restatement will belong, you have the two extremes, first restatement, second restatement. The European codifications are there. I want us to be in this side. Okay, let's take some subjects, tort conflicts. If you look superficially at these codifications, you would think that the lex loci delicti is alive and well. Well, it's alive, but not well. 99% of codifications have retained the lex loci delicti rule, but 88% of them have introduced exceptions, such as the closer connection exception, the common domicile exception, which is a particular expression of the same, the favor legi principle, and so on. We should retain a territorialist rule for conduct regulation conflicts, and the draft restatement, of course, does that. 63% of codifications have adopted the common domicile exception to the lex loci, but 2/3 of them apply the common domicile law even to conduct regulation conflicts, and that is a big mistake. The 42 jurisdictions in this country that have abandoned the first restatement have adopted the common domicile exception, but only for loss distribution conflicts. 16% of the foreign codifications adopted the pre-existing relationship exception, some of them in categorical terms. We should be very careful about adopting that exception because it can lead to exploitation of weak contracting parties, such as employees. Here you see a visual presentation of the results. They look similar, but of course we reinvent the wheel in every case, and there is this important difference between our common domicile rule and theirs. Cross-border torts. 72% of codifications have adopted the favor lesi principle, favoring the injured party, which applies whichever of the two laws, the law of place of conduct or the place of injury, favors the victim. 40% of them do so for all cross-border torts. Some do for some cross-border torts. And many of them give the choice directly to the victim. And virtually none of them allow a foreseeability exception for cases governed by the law of the place of injury. If you look at our law, 86% of American cases decided in a certain period have reached the same result, not based on the favor lesi principle, but based on the interest of the states and so on, falls through conflicts, all of that. But in all cases in which they applied the law of the place of injury, the occurrence of the injury in that state was objectively foreseeable. We should codify this result by giving the choice directly to the victim for reasons of efficiency and so on. But the choice must be for all issues, no dépassage, in other words, no picking and choosing, and it must be subject to a foreseeability proviso. The draft is in that direction. So here you see the specifics about the various countries that have adopted these rules. I'll skip that, and here the visual, same thing. Products liability. Some net exporter countries, for example, Japan, favor manufacturers in their choice of law rules. No surprise there. Some net important countries favor consumers. And some jurisdictions like the EU and Quebec want to have it both ways. I'll explain on another occasion what that means. Some countries give the victim anywhere from 2 to 4 choices between the laws of those states, and only 6 of those codifications have a commercial availability proviso for protecting the defendant. Our choice of law cases in products are a mess. There are no patterns that emerge other than what Justice Harlan, I think, once said, that courts tend to be mesmerized by context. So the more context a state has, the more likely its law will govern whether it favors the plaintiff or the defendant. The relevant contexts are these. And when one of those states has 3 contexts and the other has 1, 3 wins over 1. If it's 2 and 2, okay. Sorry, then the plaintiff wins. The plaintiff conducts win, but not necessarily because they favor the plaintiff. Okay, so I'll move quickly. My proposal is I'll have some other occasion to explain what we should do. These are the countries that give the victim a choice, and only the ones in red have the commercial availability proviso. What do I have? Party autonomy is another whole topic. I had a lot to say on that, how we are different, how we should remain different, because our law is better in some respects, but not as good in other respects because we don't draw sharp lines to protect the weak parties. But that will have to be for another day, and I understand that Richard will be talking about party autonomy. Maybe we'll have time to discuss that. So I was going to talk about party autonomy and then the area of property and so on, but and I don't even promise a paper. So if you want to know what I think, which doesn't matter anyway, maybe you can get your library to buy my book. Okay. Thank you very much.
You can leave your PowerPoint on.
No, turn on the lights.
Now I'm worried that this is actually going to blow up this time.
Everyone gets their own melody.
Different one. Let me begin by thanking Ralf and my alma mater, Duke Law School, and the Duke Journal of Comparative and International Law and its student editors for having all of us here. It is poignant for me to actually be able to discuss conflict of laws because almost everything that I know about conflict of laws I learned from Ralph Michaels in the spring of 2004 in a room that I think is actually just above this room, using Professor Symeonides' book. The other part of conflict of laws that I know from my friend and co-author Chris Whytock, and so anything that I say that's not correct in the next 20 minutes should be attributed to Ralph and Chris. Everything else should be attributed to me. When Ralph emailed me originally about this topic, he had pretty low marching orders, and they were, first of all, be novel, and second of all, be practical. And both of those in the same talk are sort of tough to do, and so I hope to try to put together at least some novel ideas with some practical ones. The basic idea that I have for my remarks is that the restatement needs to think bigger. So much of what the restatement is, at least so far in its drafting and in the first and second restatement, are what one might term garden variety torts. And these are sort of torts where rules, almost no matter what the rules are, will be serviceable and will not be subject to much contention at the end of the day between the states, who are the supposed emanators of the laws, at least when it comes to ideas of governmental interest and state interest. However, there are, as one might classify, Catherine Flory has done in a recent article, other things called big conflicts. So little conflicts are the garden variety. You get in an accident, there's negligence here, there's negligence there, it crosses a border, what should the rule be? The big conflict, among other things, are conflicts which bring in the potential for regulatory conflict between states. And so here's a possibility where international law and the international choice of law can actually take a prominent role in the restatement, and that is to say sorting out what we might refer to as big conflicts. There is a problem, however, with addressing big conflicts. And the first problem is that the increasing use in the United States of the doctrine called the presumption against extraterritoriality should, in many cases, limit the extraterritorial application of U.S. federal statutory law. I'm going to say more in a minute how the ripple effects of that decision may impact other areas of law. But for the students, the general idea is this, that unless there is clear congressional intent, whatever that may mean to the contrary, United States federal statutes are presumed to apply only within the territory of the United States. We can quibble with what sort of congressional intent and what sort of evidence you need to have and to elicit in order to show that there is, in fact, an extraterritorial intent on the part of Congress. But generally speaking, this means that for most federal statutes, they're going to be limited to conduct or occurrences or effects that happen in the United States. So on the one hand, one might say the potential for international conflicts and regulatory conflict in the United States in a post-Morrison, post-Kiobel world is not great, but that is not so, mostly because of the idea of effects. Now, Justice Scalia in the Morrison decision and indeed in the Kiobel decision talked much about the idea of focus of a statute. It would be a craven watchdog indeed for there to be a presumption against extraterritoriality if any domestic conduct or effect could be alleged to escape the presumption itself. But we have seen at various times courts, in fact, using the effects test and the idea of effects to get around the presumption itself and then to use that effect in the United States to justify the application of U.S. law. So there's sort of a two-step that happens. The first step is that the presumption should itself limit the ability for there to be an international conflict in these sort of big regulatory cases. But to the extent the presumption is, in a nuanced way, gotten around, then the application of U.S. law will be what happens in the case. And so that also will avoid the international conflict of laws. So on the one hand, we have this presumption that's working its way through federal statutory law. It also may apply to federal common law in light of the Kiobel decision from the United States Supreme Court. The question is what happens when you have the extraterritorial application of U.S. state law. And some people have written on the idea that in the wake of the fact that most federal statutory law will now be limited to territorial conduct, what will happen when it comes to the application of U.S. state law, in particular U.S. state common law. If you look at the cases, it is very interesting. In most federal courts sitting in diversity applying state law, they apply the presumption against extraterritoriality to state law, in particular state statutory law. And there are some grounds for so doing because state opinions at many times include a presumption against extraterritoriality, as indeed we have in the state of California. But even when there is not an explicit reference to the doctrine of extraterritoriality in state decisions, most federal courts sitting in diversity, at least as to federal statutory law, will in fact apply it. When it comes to state common law, the result is incredibly mixed. And what is surprising about this mixture is that courts are tending to get around from this potential for an international regulatory conflict. That is to say, the potential application of U.S. state law when it might conflict with the application of foreign law, not by engaging in choice of law, but by engaging in forum nonconvenience. Now, this is not in all cases, but it's in a lot of cases. And what you then, in fact, see is that forum nonconvenience is being used as a short-circuit method for conducting the choice of law analysis. So in one recent opinion, and it's not just forum nonconvenience, I should say, there are other doctrines, including the doctrine of international comity, which I think that the Foreign Relations Restatement is taking up, but I would encourage this restatement to, in fact, take up, is also being used as a doctrine to short-circuit a choice of law process. So in one recent case, the Mujica case, involving acts that happened in Colombia, it originally was an alien tort statute case, but after the alien tort statute claims were dismissed, the court was left to have to deal with the state law claims, in particular the California state law claims. And the Ninth Circuit noted that when looking at whether or not California law, or in this case Colombian law, should be applied to acts or occurrences that were occurring in Colombia, the court said we should look at several non-exclusive factors. We should consider, when assessing U.S. interests, the location of the conduct in question, the nationality of the parties, the character of the conduct in question, the foreign policy interest of the United States, and any public policy interests. And so in reading those standards, you might say, oh, the court is in fact applying a choice of law analysis. It in fact was not. It was applying an international comity analysis to dismiss the case in favor of Colombia. and way conducting a forum nonconvenience analysis without conducting the independent and adequate alternative forum analysis, because there was, in fact, no independent and adequate alternative forum, because if Colombian law was to be applied either in the United States or in Colombia, there would be no recovery because of the statute of limitations. So to get around this whole thing, the Ninth Circuit in this Mujica decision used international comedy as a proxy for conducting a full choice of law analysis, and yet relied on the same or some of the same factors that one might rely on if you were doing a comparative impairment approach, for instance, in California. That is to say, the interest of the United States or California in the application of its law, the interest of the foreign jurisdiction, and then the comparative impairment prong, which is the third prong in California. And so, on the one hand, we have to say that extraterritoriality is going to be a doctrine that should be discussed, I think, in this restatement, not as a species of foreign relations, but as a species of an intervening choice of law rule, because the doctrine of extraterritoriality seeks to avoid the choice of law process. Number two, I think that we need to look at the ways in this restatement that forum nonconveniens is precisely being used to short-circuit the choice of law process. And number three, I think it's important for these doctrines, because they pull in both directions and in some ways overlap, to take account of the fact that much of this work in this area, much of the development of the law in this area, has to do with what I referred to in the beginning as big conflicts. That is to say, big regulatory conflicts, big aggregate class actions, in particular if they're cross-border class action conflicts that are different than, because they implicate foreign relations, the garden variety torts that the restatement so far, the first and second, and also this one from what I've read, have been concerned with. So those are some observations on the state of the law. And so all this is to say that I think there can be a monumental improvement for this restatement, specifically and concretely focusing on international conflicts as a standalone, in particular in big regulatory cases. Not because I think that they can restate the law as it presently exists, because I think in restating the law, what you will in fact see is a lot of obfuscation on the part of courts, because they do not necessarily know what they're doing. We could say quite simplistically that what they're doing is getting rid of these cases on discretionary grounds because they do not want to deal with them. However, if you talk with judges, you sort of get a mixed bag of opinions here, because in most of these cases, judges could in fact apply California law or some other U.S. state law to the facts. They are obviously familiar with applying U.S. law to facts every day, and so it's not the fact that there are international elements so much as the fact that there are other concerns, apparently, that judges have, and thus they're using recourse to other discretionary doctrines instead of conflicts and choice of law methodology. So I think this restatement should take account of some of those issues. Now, besides making the observation that international comedy, I think, should be a part of this restatement, also that forum nonconveniens should be a part of this restatement, I think that some discussion of the interplay between extraterritoriality and choice of law, and in particular the use of extraterritoriality when it comes to the force of U.S. state law, should in some ways be taken account of in this restatement, because I think of what the foreign relations restatement is thinking of are these doctrines in quite remarkably different ways, not as a species of U.S. law or of conflicts law or of methodology, but as a statement of pure international law and foreign relations law of the United States. So it would be beneficial to have the expert opinion of others in this area who are not looking at this as a matter of foreign relations, but as a matter of choice of law, to me may bear on this area, because I think it might help judges, if they had more clear direction instead of just balanced factors, to make decisions of whether or not a choice of law analysis should be conducted either before conducting a forum nonconveniens analysis or before, in fact, conducting the international comity analysis. Now, the other thing that I wanted to mention is that there are other things that might be taken account of, at least in terms of this restatement, as it goes about the process of internationalization. Number one is, how do you deal with cases that actually do have government conflicts, state interest conflicts? It was written a while ago, the governments don't really have interests. We can look far and wide to find cases where they enter and actually have an interest. Well, there are actually a lot of them. Just a quick search last night after I came back from a lovely dinner, I was able to find 5 in the past several months, including from the government of Jordan, the United Kingdom. China had 2. There are now lots of amicus briefs being submitted in lower courts for various reasons. There was an interesting case recently in the Second Circuit involving foreign sovereign compulsion, where China filed a brief basically saying that there was a requirement that someone abide by the antitrust law in their jurisdiction, which created a true conflict, and this means that under the doctrine of international comity, there should be abstention here, which the court effectively adopted. So in a way, the restators should take account of the fact that governments are now entering cases to state their regulatory interests. And what do you do with that? I'm not sure there is a clear rule But besides, offering the counter rule that any time a foreign government enters the case, it would be beneficial for the court to also solicit the views of the United States, which surprisingly they all don't always do as a matter of course. It is something that I think has to be dealt with, and I'm not sure if it's being dealt with in the Foreign Relations Restatement, but it should perhaps be dealt with in this context because there are significant number of foreign government submissions. Kristen, what's her last name? Yeah, Eichenser at UCLA, who just wrote a piece on this involving foreign government submissions in the United States Supreme Court, is currently working on a piece involving foreign government submissions in the courts of appeals. I asked her about it, and she's found 100 already that exist. So there are 100 statements of foreign governments in the lower courts of the United States involving the application of their law. It seems to me if you want to know what a government interest is, you have the ability to ask right there. But the question is, how do you deal with it? The second thing that I wanted to propose, which I think has been alluded to earlier, is that the restatement as part of its internationalization efforts could include as part of its notes comparative materials. I know this is something that the Restatement of International Commercial Arbitration has tried to do. I think Ralf mentioned the agency restatement has also tried to do it. Of course, we have to deal with the issues of thick and thin descriptions, how far and how deep, and what role they play, at least in the context of the Restatement for International Commercial Arbitration. I believe the treatment has been quite minimal and also just sort of as a sort of see also kind of citation. Now, whether or not this restatement gets into it more deeply, I think what it can do is point scholars and others to the fact that there are other ideas out there, and I think of the remarks that Professor Symeonides just gave and also his book already does a lot of the work for you. So if you just want to drop in citations, there you have it. And the final thing that I think this restatement has to consider at some level is whether or not, and this gets back to something that Linda did a number of years ago, whether or not there should be uniform federal standards in this area, in particular if they involve foreign relations. And obviously there's a model statute involving the enforcement of foreign judgments, which this restatement might want to take account of because of the unique foreign relations implications of enforcing foreign judgments in this country. But one might ask the same question about foreign law in this country. In a lot of these cases, what we will see is courts applying state law. Now, to the extent there are federal district courts sitting in diversity, applying state law or applying state choice of law rules, which either lead to the application of state law or foreign law, we have to presume that the federal courts are taking account of federal interests because they are indeed federal judges, even if they're not doing it explicitly. But so much of what is happening in this area, and probably will continue to happen in this area, at least in the area of torts, will happen at the state level, and it's not always clear, especially because of publication rates and other things, how and to what extent state judges are in fact taking account of federal interest in this area. And so I have no proposed solution, maybe Linda will in a later panel, about the content of whether or not there should be uniform federal conflict of laws rules, at least in the area of foreign relations or foreign affairs, but it's something that at least should be considered. So let me return again to, in closing, to the thoughts that I sort of offered in the beginning. I think it is a tough task in a way for this restatement to deal with international conflict of laws because if they are restating the law as it exists, judges have done it quite poorly. And I think we can offer many reasons that judges have done international conflict of laws cases quite poorly, but one of the reasons is they've been given very little guidance besides the idea in the second restatement that they should balance the interstate and international systems in coming towards some conclusion. I think that one improvement this restatement can offer is to provide guidelines looking specifically at recent cases and not just the textbook cases that exist in conflict of laws books, because most of those cases are domestic in focus and, as I said earlier, are little conflict garden variety sort of cases, and looking to some of the bigger cases which might create an overlap with the Restatement of Foreign Relations in terms of some of the issues that it's addressing. But there's no reason why this restatement shouldn't give a fresh look and shouldn't bring to bear with it the considered judgment of conflict scholars as opposed to foreign relations scholars. I think this restatement also needs to take greater account of issues related to forum nonconvenience, international comity, when it gets to the jurisdictional parts of the restatement. That'll provide an interesting discussion in and of itself, in particular because, at least if the current Supreme Court case law is to be believed, there must be some contact with the state for it to apply. It's for it to assert jurisdiction, and if there is some contact with the state, there's likely some effect in the state, which would then justify under constitutional due process and Allstate versus Hague the applicability of that U.S. state's law to the underlying cause of action, which means that in many cases, if the reported cases are to be believed, there will be an extensive application of U.S. state law in many cases that even have international contacts. I think taking a hard look at those cases as sui generis international cases, as different than garden variety tort cases, looking more specifically at the big regulatory cases and the doctrines like international comity and forum non-conveniens, could in fact not just improve the scholarship in this area and not just improve the restatement, but could actually improve judicial decision-making in this area. And as I said before, I think one of the issues that would be interesting to take account of and to deal with is what to do with foreign government submissions, especially to the extent that this restatement using interest analysis is focused on state interests. And what do we do with the submissions of foreign sovereigns in particular, if not the United States, that describe precisely the interests of their states? Do you accept those? In what cases do you accept those? If there's a conflict between that interpretation, not of the underlying law, but as to the applicability of U.S. law, who do you defer to and how? These are not questions I have answers for today, but before the phone blows up, I will say again, thank you for having me, and I look forward to the discussion. With 2 minutes to spare.
I should give those to Symeon, right? Thanks, both of you. Thanks also for keeping with the time, and especially in Symeon's case, not talking about, I hope you'll have a chance to talk about some of the things that you have there. I hope everyone has the book. The library has the book. I have the book. It's a very good book. The reason I'm relatively strict on time is that we really have expertise in the room, and I hope we'll bring that in. These are the two kind of broad theme presentation, one on comparative law, one on international law. I think they already raised some concrete questions. I have one that I'll ask for Symeon to start us off maybe, and that's the question of escape clauses. I can see why we might want escape clauses in codifications that are binding law, and why statutes have those. I would wonder your view whether a restatement needs an escape clause, or whether we could say a court will anyway say, this is a case for which the restatement rule was not made, and because it's not binding for me, I'm just not going to apply it. So would the restatement have to say where it does not apply, or could it leave that simply to the judicial process?
Well, of course, it depends how categorical the black letter rules will be. You might take the position that all of the restatement is soft law. Judges have the option of following it or not following it, or following it with modifications and so on. Fair enough. But I think one has to aspire to produce a complete system rather than, and so if you have categorical rules, for example, looking at the present draft, it does say that if the issue is one of loss allocation and both parties are domiciled in the same state, then the law of that state governs under, rather than the law of the place of the tort. That is a rule that emerges from the American experience. It's a sound rule, I think, and so on. But there are some circumstances in which that is not the right result. Some of you will think that Schultz versus Boy Scouts was an example on point. If you add a few more facts, maybe it's even a stronger case for a different result. So how do you enable that result? Do you facilitate it? Do you allow a way out? You can say, no, this is our rule, and if you don't like it, don't follow it in the particular case. But I think it's better to have an escape and have it drafted carefully so as to be a guided escape. It's not because you don't like the result. It's because this result would be inconsistent with the higher principles of the general approach or whatever. So in that sense, I think you do need to have escapes even in a restatement if you want to have a complete system. And in the end, time will show if the rules are good, the restatement, the escapes will prove unnecessary or will not be used as often. If the rules turn out to be not very good, then you'll see that out of the escapes will derive the new restatement 50 years from now. That is, in a sense, what happened during this period. The second restatement was so loose, so flexible that it didn't give courts enough guidance, but that was perhaps the better approach for that transitional period. From that flexibility, courts develop these uniform patterns that we now codify in the restatement, in a sense. But learning from the lessons of the past, I don't think we should be too categorical. We should have rules only for those cases and issues from which we have enough experience to say these are good decisions, and even for those cases, allow the possibility of an escape. So that's my view.
And to make sure I do something in my capacity as chair, I also have a question that actually I think is for both Trey and Symeon. So if we do decide to take seriously some distinction between big and little conflict of laws issues, whether it's defined in terms of regulatory and non-regulatory law, or conflicts that have implications for foreign relations or not, is there any guidance that either you have reflecting on your presentation with your talk, or Symeon, based on your experience with codifications, about how this distinction can be drawn in a coherent way that will provide somewhat reasonable guidance to judges and parties, so that it won't end up being subject to manipulation to try to, a tool used to argue for foreign law or foreign law in particular situations? I'm trying to imagine how, I mean, since private law is so intrinsically regulatory in itself, is there a way of defining this distinction in a way that would be operationalizable for the courts and for parties?
Well, I think just sticking with international law, one way is precisely to identify, as you've partially done in your NYU article, more recent cases that have involved the potential application of foreign law. That should take a larger subset and make it a smaller subset. And out of that subset, I think what you would then have to look for cases that involve true conflicts, because in those cases, you're going to have the clash of regulatory regimes that would necessitate perhaps having a different approach to choice of law. So I think part of the answer is to do it empirically. I think if you were looking at the way Catherine Flory uses those terms in her recent article, she talks about decisions that could potentially have foreign relations or regulatory impact outside the United States, or those that have important public policy goals, and you can see how defining it in that way almost swallows everything. But I think, at least to begin with, what you would want to do is look to see about cases that were involving the application of U.S. foreign law. So, I mean, the big ones that we see, obviously, are the application of state tort law, post-alien tort statute, the application of state securities law. After Morrison, you don't actually see all that much in those cases that's going to be all that helpful. And so then you have the antitrust cases, the FTAIA cases. And again, those cases have tended to be quite limited. And so I think, after you create the subset and divide it further into those cases where there's a true conflict, you might have some possibility. The other way of looking at it would be just to see cases where foreign governments have filed amicus briefs. That might give you a better sense of the types of cases where these issues arise. And obviously, if you're looking at international IP, I think there's a big potential in terms of trademark, for instance, and intellectual property infringement for there to be separate rules for that, although I think you mentioned in the beginning that there may be a separate IP section, but even within that section, there might be some international account of what's going on. I don't know if you have any ideas.
Well, I hesitate a little bit to accept one of these premises, that is, that some cases involve the interests of foreign countries, and on contrary, all the rest do not.
Right.
So I would not, for example, I would hesitate to have the filing of amicus briefs as a criterion. Incidentally, some years ago, one conflict scholar disputing the whole idea of state interest said, if it's true that states have interests, why don't they file amicus briefs arguing for the application of their own law? And so I did some research and have discovered that happens not only in foreign cases, you're absolutely right, maritime cases routinely and so on, but also in interstate cases. You have the Attorney General of Minnesota appearing in Wisconsin to argue for the application of the franchise law of Minnesota, for example. So, for those of us who think that many conflicts cases involve state interests, there is nothing new there. You are right, it has become a more prominent phenomenon recently in international conflicts, but Kerry thought that was always the case, even without amicus briefs. So, but of course, what you said makes perfect sense, and I would go about by separating in subject matters. Antitrust, other regulatory, and there, once you focus on these subjects, you will see that the foreign or the governmental interests are always prominent in a way, and you take account of them that way. Other than that, I would hesitate with any other generalization. But you are absolutely correct that these mega conflicts now. And you are also correct that we don't use those cases in case books because they are very, pedagogically, they are not good vehicles to teach students about conflict law. It's difficult enough as it is, so we prefer the simpler cases to expose them to the basic dilemmas, and then hopefully in more advanced courses we use the mega conflicts. I don't know that this is helpful, but what Trey has been suggesting is a good area for you to start thinking about.
So I saw Matthias's hand up already. I want to invite comments, including from the students. Absolutely.
And I think our goal, by the way, was to make things complicated and then have them figure it out, right? We weren't supposed to provide solutions. We were supposed to complicate, be novel and practical.
Right, that's part of the
create more work for you.
Part of the education process. Let's get 3 comments in a row. Let's have Matthias and Pat and then Horatia.
I have one quick comment regarding the escape clauses. I think you have to be very careful before you extrapolate from the use of escape clauses in the codification that Sim is talking about to escape clauses in the restatement, because much depends on in whose hand you put them. If you put escape clauses in the hand of a European judge under a European regulation, it will be handled with great restraint. European judges do not resort to escape clauses quickly because they believe in rules and predictability and high determinacy of law. Actually, a current student of mine, she's part of a research project, and they do try empirically to figure out how easily do European judges resort to them. They're very reluctant. There are very few cases where European judges say, yeah, that's what the rule says, but we like the exception. If you compare this to the practice under the Second Restatement, you see immediately what I mean, because judges are very quick to say, yeah, that's 145 says, but we like rules Section 6 better. So you have to take that into account. If you give an American judge an escape clause, that's a big license. If you give a European judge an escape clause, that's a very small license. I find what Don said very interesting about the extraterritoriality cases, and I have a question but not an answer. You said it avoids the choice of law process. I think the opposite is true. I think it triggers the choice of law process, because if you, in some sense, right? Because if you say these statutes apply, then they apply and the game's over. But if you say they don't apply, that's not the end of the story. We treat these cases often as if, well, therefore, the end of the case. It may be de facto the end of the case, but it's the end of the case only if jurisdiction goes, right? But sometimes it goes and sometimes it doesn't. Remember the old cases when the federal courts were saying, if we don't apply the Sherman Act, we don't have 1331 jurisdiction, but we now know that's not true. So jurisdiction may linger. So the case may linger, and we see this more and more. So in that sense, once you say there's no extraterritorial obligation, you kind of go to the choice of law question. You have to say, what are we going to do now? I take the Morrison case. You could bring the same case still under general fraud provisions, toward fraud provisions. American fraud provisions? Australian? You could easily make a case that with regard to the Florida defendants, Florida fraud law applies. You can have a viable case in Florida state court about that. So we will have to deal with the question how we deal with the choice of law issue in the wake of extraterritoriality decisions, right? Because they don't close it off. And then the question that you pose arises, do we handle them by form of convenience or by international comity? Or do we say, what is the impact of a non-extraterritoriality decision on the subsequent possible choice of law process? And that's a hard question, but I think the restatement better address that, because that's going to be on the table.
You want to jump in?
Just very quickly, I mean, the problem, of course, is the public law taboo that sits there as well. I mean, if you use the choice of law process, and you might say Australian law applies in something like Morrison, and there have been other cases in which there's been an attempt to try to bring some of these cases under the foreign securities law. I mean, you're going to lose under the fraud law. You need the securities law and the higher standard. So the real question, and again, if you're a restatement, I don't know that you have much choice, because one could think about rethinking the notion that you do not apply public law. Why the Australian securities law is in somehow public law, I'm not sure, but as restaters, that really is the state of the law if you can, as one of the other restatements put it, do a progressive nudge. I mean, maybe there is something to sort of rethinking what is in fact public regulatory law and why then does the choice of law process break down. But I just wanted to add that piece, Matthias.
Wonderful. More to do for the reporters. Pat.
Well, I have three kind of loosely connected observations. One is that, and I think you owe me a footnote on it's not your grandfather's conflicts codification, because that was my line when I was writing on the Louisiana codification. And no matter how hard and fast the rules are or aren't, there appears to be an advantage to at least having a common vocabulary, because before there was the codification, Louisiana had this odd admixture of interest analysis in the second restatement, and the reversal rate in conflicts decisions was 50%. I mean, it was as good as a coin flip. It got to over 80% without, in my view, an overly rigid codification. So there's that. One thing I think people should probably keep in mind with regard to talking about the second restatement is there really are sort of two second restatements. There's the second restatement that we all know and love, which is a block quotation to Section 6, a block quotation to Section 145, which adds to 11 factors, and courts pick and choose them as they see fit. I specialize in snotty law review articles, but there was a New York Court of Appeals case, Stolars, which involved an insurance contract conflict, which they attempted to reason out from Section 6 to Section 188, apparently completely oblivious to the fact that there was Section 193 that deals with insurance conflicts. And so my suggestion was that if they were going to follow the second restatement, that they might want to buy a copy of it. So in a way, I think the second restatement gets a worse rap than it deserves, largely because all of the generalizations came up front and people never really looked past those to get to the other ones. So, before we pitch all of that out, I think it's worth thinking about, and one of the reasons I like so much better the conflicts draft here, or the tort draft here, is we start off with some fairly specific provisions, and then we get to the end, it says, okay, if none of this works, we're going to do something different. To me, that's a much better way, that's a much better way to go at it, and I had a third observation, but I forgot what it is. So anyway, enough.
Yeah, thank you very much. Mine is a bit vague too, but it's in response to what Symeon was saying, and in Symeon's description or panorama, and then what Don was saying about foreign non-convenience and other jurisdictional mechanisms. It seems to me that it's very, very difficult to think about all these issues without having the framework on jurisdiction in mind. And so my big question, but I suppose Linda will be talking about this tomorrow, is to what extent does the jurisdictional factor have to be considered in everything? Like, can you really think of a choice of law rule without thinking about the jurisdictional framework? And in Symeon's panorama, many of these codifications do have a very, very similar jurisdictional framework too. In other words, for most of, perhaps not for most, because all these countries are so different, but I mean, in many, many cases, the jurisdictional rules are quite limited, non-discretionary, and they imply quite a substantial link between the court and the case. So, can you think about choice of law in general without, and this probably links up with the question as to whether to distinguish intra and international cases. The jurisdictional structure is different in the two cases. So, can we think of choice of law in the same term for both? It's a sort of an open question, but I think these foreign nonconvenience things are really very fascinating.
Well, thank you. I had 2 points. The one is actually just following on from that, because I come from the legal system. By this, I mean the English national legal system rather than the European system, which we at least currently belong to. I mean, in my world, in the world of English conflicts of laws, we don't have choice of law disputes. I mean, they almost never arise. I mean, if a judge ever actually had to decide a question of what law governed and determine liability on that basis, I'd probably take my wife out for dinner and there'd be a huge celebration. It just never happens. And the reason it never
Which part never happens? You never take your wife to dinner?
And of course, the reason for that is, I mean, I won't go into all the detail, but the reason, as you know very well, is that almost all our conflict disputes are heavy commercial disputes. We have a large number of disputes about jurisdiction, interlocutory relief, and the case will settle once that issue has been determined. So we invest all our effort, and I should say the parties invest a great deal of money into the question of jurisdiction, but the chances that even if the English court took jurisdiction, the case would never go to a trial on substance is just almost unthinkable. Having said that, the choice of law question does factor into the question of jurisdiction, and in particular the question of foreign convenience, because the court actually has to make a preliminary determination very often of what law governs and what its content is in order to determine what you should hear the case at all. I simply make that observation on the back of what Horatio said. If I may, that wasn't actually the point I was going to make. First of all, when I put my hand up. I mentioned the European context. I'm not sure, since 23rd of June, whether I'm entitled to speak on behalf of the European legal system, so to speak. I'm not sure whether I'm a European. I was going to make this point, though, that I think there are dangers inherent in making a comparison between the US system and the codified European system. And I think there will be dangers for the restaters in attempting to draw lessons from the codified European experience. And that is simply because the European context is so distinctive. It is so unique. I mean, it may seem a strange thing to say, but you have to remember that the objective which lies behind the European codifications, and I mean in relation to contract talk, but also jurisdiction, that the objective which lies behind those is not to arrive at the best conflicts regime, oddly enough. It is not designed to get the best rule and so as to get the best result. It is designed to get the best rule and the best result subject to certain very specific constraints which are particular to the circumstances of the European Union. That is to say, the objective is to further the internal market. The objective is to secure the four freedoms, the freedom of movement of persons and capital and so on. And those are perfectly proper objectives, but they are the underlying objectives of the entire corpus of European law, which includes the rules about jurisdiction and choice of law. And they are very distinctive. I mean, I've attended meetings in Brussels where essentially a decision has been made, not quite in explicit terms, but in effect a decision has been made not to have the best possible rule, but to have the best rule which suits these objectives, which are independent. Secondly, and of course it is certainly the case that there is famously a high degree of flexibility in the second restatement, and there is a much lower degree of flexibility in the European system. But of course that's not because a decision has been made that certainty is better than flexibility. It's because if you discount common law systems within the EU, that's to say, of course, principally the UK and Ireland, all the other member states are states in which the degree of judicial discretion and judicial independence which you need in order to operate a flexible system simply does not exist. In other words, it's not actually a choice between flexibility and inflexibility. In a way, there is no choice at all. And just if I may, to just add a vignette which sort of makes that point, I can remember at discussions leading towards the finalisation of what became the basic choice of law rule in the Rome II regulation of the choice of law in tort. I can remember that the UK was actually very keen on the idea of adopting something like the American restatement approach, of having a rule and an exception, and then supplementing the exception with considerations which you'll be familiar with, of course, party expectations, all this sort of thing, give the judge some guidance as to what that means. We were roundly shouted down on the basis that a flexible test which provided a judge with a set of desiderata of that sort would simply be unworkable because most judges would not be able to operate such a test. And of course, so it became, if I can just make the final point, because there is, of course, in reality, no flexibility in our choice of law rule in tort, because the flexible exception is actually a mirage. It's not just a mirage because of reluctance to use it, it's because, for reasons I needn't go into now, the flexible exception is structured in such a way that it can almost never be used. In other words, I think the UK that was very keen on having flexibility felt that we'd perhaps rather missed what was going on, actually, in terms of this were agreed. My underlying point is this. If you want to draw lessons from the European experience, then I think one has to be very careful about noting the background to it.
Yes, absolutely. I hope this is something that at least Horatia will speak to tomorrow.
Absolutely. Tomorrow?
No, today. and today. And all the time, I'm sorry.
I might talk about it today, but not tomorrow.
Good, okay.
Yeah, when I talk about European codifications, I don't mean simply, and sometimes not at all, the EU projects. I mean national codifications as well as the EU regulations. In fact, when I was writing that book, I wondered for a while, you know, what is the point of talking about the Austrian codification? Because when it comes to torts and contracts, it's now superseded. Not entirely, but 80% of it. In the end, I decided to include all of those national codifications because my objective is comparative law. Is not to guide practitioners in what the current law is, but I wanted to see how the legal mind progressed from the 60s to the 70s to the 80s, from national codifications to collective projects and so on. So at least when I talk about European law, I include the national codifications and some, of course, what you are absolutely correct, Richard, that the objectives of some of these regulations are not necessarily to come up with the best possible conflicts law, but to accommodate a lot of tensions and other conflicting objectives. And one of the effects of these regulations was to bring some of these countries down and raise other countries up, so they're all in the middle now. But if you take a country like Belgium in 2004, they had a very, very good national codification. For them, Rome II is a step down. But if you take a country like Greece, whose codification is 1940, it is a big progress for them to have Rome II and Rome I. Now, on the issue of escapes, you are both correct, and Matthias, that the European judges are very hesitant to use these escapes, which are, for that reason alone, drafted in very tight language. For example, the first modern codification to use an escape was the Swiss codification of 1987, and we now have how many years? And there have only been 3 or 4 cases using that escape. Okay. At the same time, go to the other extreme, you think the Germans would not like escapes, for example. Well, no, because that's what they told me in Brussels when I spent those 6 months. We were talking about matrimonial property, and they said, we need certainty. And I pointed out to the German codification. In the law of property, can you believe that they have an escape? They have 2 or 3 articles. One covers immovables, the other movables, and there are standard rules. Yet there is an escape from all of these articles. So even in the area of property, they thought of the need of an escape. I think Bismarck will be turning on in his grave these days. So it's not, you know, so it's not only the EU regulations that have escapes. And speaking of those, by the way, in the law of successions, the successions regulation, you know, I think it's a very good regulation because compared to our law, it focuses on the person rather than on property and the idea of a single unified estate, and that is the applicable law, the law of the last domicile of the decedent. But then there is an escape right there. If another country has a closer connection, you apply the law of that state. And so all the notaries and the attorneys who wanted more certainty didn't get it. So even in Brussels, it is possible to come up with some good conflicts law. I would not dismiss it as easily. And at the same time, I was many times on the side of the UK and the Irish delegation when we wanted to get some more flexibility. I think what you are referring to, Richard, is Rome II, where the rapporteur was Diana Wallis, a British parliamentarian, and Pat and I were advising her, and she drafted indeed something like a restatement. It was too American even for my taste, and in the end, of course, it was defeated. But as you know, the process, it was already in Parliament. You had to go back to Council and all of that, the trialogue. But anyway, I do hear you for the rest in that we should be careful in drawing from the EU regulations because of the special circumstances of those regulations. But there are still a lot of things we can learn from them, as they have learned from us, I think, whether they accept it or not.
And one more.
You have your third point.
I
Louise first.
Everybody goes first before me. Yeah.
Symeon sort of raised the question, I think, of the political dynamics. And I think that is true with hard law, in particular conventions, certainly at The Hague as well, the realities of coming up with the compromise, where the restatement is closer to soft law and the politics don't create as much of an impact.
This is really a question, given what Trey had said, and something that permeates this whole discussion. And it's just a pet peeve of mine, so I just like a reaction. We always talk about interests, and when I'm teaching conflicts, I absolutely refuse to allow the students to use the term interest, qua the way you were talking about it, state interest. It's a notion of trying to look at what the purpose of the law is rather than the state having an affirmative interest. And I have to say, when I was teaching last year, Jürgen Bazado came to my class. He was a fellow at the center, and he would put up his hand and he'd say, I can't understand this interest analysis. If you're really trying to find the state interest, you'd have to be looking at what the legislature did and so on and so forth. And I said, no, that's really not how we necessarily think of this. You may be able to find something stated, but we really are talking about purposes, and laws have purposes, and we know what they are. And so, this is actually a question to the reporters and so on, whether or not you are tied to the notion of using interest in that particular way. On the other hand, the kinds of cases that Trey is talking about, I think, are cases in which states have interest, and it's not because they are filing amicus briefs. They do that when somebody asks them sometimes, or it's a client or an important player. But because these are often regulatory regimes in which the states have themselves strong policies, and they are part and parcel of the regulatory regime in a much stronger way. So I just thought I would throw that out there given the discussion, and I guess it's really a question to the reporters of whether they see a difference and whether they are wedded to the sort of interest that we have lived with, of course. And again, as restaters, there's a host of case law that you are restating, and we see, interest analysis is there, but maybe interest analysis isn't interest in quite the same way.
Say something?
Sure. I think that's a very good point. Interest is a word that we use sometimes. It's a word that you encounter a lot in the case law. So we use it sometimes in describing that. I think, in the case law, it's probably inconsistent. In the scholarship, it's inconsistent. People understand a lot of different things by the concept of a state interest. And to the extent that people resist it, they're usually talking about this idea that the state as a sovereign personified has some interest. And then, yes, you would want to know what the legislature thought and so on. The way that we use it, I think, is more just to say there's an interest here because there's a policy behind the law. It's supposed to apply in certain circumstances and not apply in certain circumstances. And here's a situation where the policies are at stake. So, me personally, I think it would clarify things if rather than talking about whether a state is interested. We just talked about whether its law reached these facts.
Absolutely, and I would just encourage you to continue in that direction.
And I'm trying to move a little bit in that direction as far as it is acceptable to everything and consistent with all the cases.
Can I add something?
I'll just say that I smiled broadly when you started to talk, and that is because the idea of asking the state if it has an interest always struck me like asking the kid if they want the candy and deciding whether to give them the candy. That is, it evokes sort of this indulgence, which we don't necessarily need to do. So I like whether the idea of whether the policy reaches this particular situation.
Restatement for dental hygiene, I like that. Symeon.
But the idea that states only care when there is a conflict in what we call regulatory laws is, I think, is too narrow. That's why you may not like the term interest, but a state enacts a law or adopts a rule through the common law sometimes for a reason. It has a purpose. It has an objective. And if that objective would be promoted by applying that rule in the particular case, then you can say the rule is intended to reach the case, or I would say the state has an interest or has a reason to apply it. And of course, that's only the beginning of the analysis, is not the end of it. But to say, on the other hand, and that's what the Europeans used to say, that this whole thing about interest analysis is crazy because states don't care, says Kegel. Well, because they tend to personify the state, and Curry helped them by using the wrong words, governmental of all things, governmental interest, meaning the government cares. No, it's a state, it's a society that adopted that rule that has a concern. And when you don't apply its rule in cases where, in their view, it should apply, someone suffers adverse consequences, the parties, of course, but also that society. So there are, in my view, in many cases, state interests are implicated. But you're right, the term by now it has a baggage. So that's why I talk about policies, concerns, and values. And back to the regulatory thing, when the Netherlands, for example, has a rule about same-sex marriages, and they had it, 10 years ago, it's not because of an economic concern that they have or a regulatory concern. It's because they believe strongly in the principle of equality, and they say anybody who is connected with the Netherlands, even through some a year or two of residence, has the right to get married, a person of the same sex, even if otherwise they would apply the national law of the person. So there you see how a strongly held societal belief determines the shape of their choice of law rules. So it is their own admission now that this is not a value-neutral exercise, that societal values are implicated, and whether you call these state interests or something else, it's really a secondary matter. But I think even they admit, in Germany, a lot of people admit that, of course, we're talking about state interests, and not only in antitrust, by the way, but also in family law and contract law and property and so on.
I guess the one additional observation I would have is that oftentimes determining the purpose of a law is going to lead you to the territorial application of the law. And except when they're explicit, except when exceptional circumstances. I mean, at least you don't think so?
The kind of conflicts you deal about, yes, with. But
well, that helps because I'm halfway right.
We deal with, no. I mean, damages limitations are not meant to be territorial, for example, and turn to be personal. One of the things we learned from this whole experience is that not all laws operate territorially, as they thought at the time of the first restatement. Even in the area of tort law, some of them indeed operate territorially, conduct regulation, but some of them figuratively follow the person. Immunities, charitable immunities, intrafamily immunities, limitations on damages, workers' compensation immunities, all of these may well follow the person. But you're right that in the area of federal conflicts of federal statutes and so on, the presumption of extraterritoriality has has killed all the progress we have made in the previous 40 years in choice of law thinking.
Yeah, the observation I was going to get to, though, is how do you determine, when it comes to common law, the purposes? Because I think that the common law purposes seem different to me than statutory purposes, and common law purposes might take account of purposes beyond that individual state, but as to other purposes common to all states. And that, I think, raises other issues in interpreting government interest or state interest or whatever you want, purpose or interest or value or whatever, because of certain ideas of the common law reflecting common societal goals outside of a state.
Let me throw something in too, just because I'm thinking of it. One is, in part, this is the discussion since the 1960s, right? Whether we talk of interests, policies, purposes, scopes, territory, and that's an important theoretical question. The promise, I think, in the restatement was at some point, and might still be, to say we don't have to resolve those, right? So the attractive thing in a restatement would be to say, if we can lay down what the applicable law is under certain conditions, we don't have to determine whether we talk of governmental interests or purposes or policies. We can leave that to law professors, but we have something that can be applied without that deep level. Have a code or a restatement that is compatible with different methodological approaches. I think that was your hope in the beginning. And my hope would be that you can stay with that and deliver something that makes Linda happy and Symeon happy and many others happy without having to resolve the differences between them. And makes Pat happy. I'm making Pat happy now because I come back to you.
Okay. Third one, which is that I'm not sure that amicus briefs are the greatest proxy, because in Morrison, we had all these countries saying the Exchange Act, no part of it. But then we got to RJR Nabisco. We love RICO. We want all the RICO we could get to get at the cigarette smuggling scheme. So I'm not sure those are the greatest proxy, actually, for so-called state interests. And I do agree very much with Linda about maybe getting away from that term as it's been used. I agree with Symeon and Linda on that. So that's all I have to say.
We didn't come here to agree. We came to discuss. We are complex people.
And we can agree tomorrow. Today we should disagree.
It's our break now.
Other points we can run over because we have generous breaks in the schedule. But we can also take a generous break. Thanks, everyone. We start back at 4:15 sharp.